All right, so I have 5 o'clock on the dot, and I anticipate we will have quite a few folks join us as we have in weeks past. But for those of you who are here and on time, we're going to respect that and we're going to get going. So, welcome to session 3 of the Center for the Study of Government and the Individual's Civics Refresher course. We are super excited to have you here. And uh, and look forward to a really robust discussion tonight about the judicial branch and about the Bill of Rights. I know Dr. Dunn has put in a lot of thought and time into putting something together for us, and I think it's going to be absolutely fantastic. Just as we have in weeks past, and for anyone who is joining us for the first time tonight, welcome. We highly encourage and welcome questions and discussion. Josh is going to go through his section though, and we'll leave ample time at the end for questions and discussion. But as we're talking, if a question pops to mind, please feel free to enter it into the chat box so it doesn't get overlooked or missed. And you're also welcome to use the raise your hand functionality. If you hover your mouse down at the bottom of the screen and click reactions, you'll see the raise your hand option right there. And Josh and I are both watching the chat. Please feel free, if you also would prefer to ask a question anonymously, you are welcome to send it to me in the chat box. But with that, I will turn it over to Dr. Dunn and he will get us started. So Josh, they are all yours.
Great. Thank you very much, Shannon. Wonderful to be back with all of you. I think I see some familiar faces from the first time I did one of these. And again, we're just delighted to be able to put on these programs. We think that increasing understanding of our Constitution and America's political traditions is crucial for creating a vibrant civic culture in both Colorado Springs, Colorado, and throughout the country. And so I really have enjoyed this and developing this program. And I want to thank Shannon as well for all the work that she has put in to developing this program. So today I'm going to be talking about the judicial branch and the Bill of Rights. I just want to go ahead and tell you that most of my courses focus on constitutional law, so the Supreme Court, and then the Bill of Rights and 14th Amendment, so civil rights and liberties. And I have to confess that it took Herculean levels of self-restraint to not include a lot more stuff in what I wanted to talk about today. But I did just try to narrow things to just focus on what I think is really crucial for understanding the nature of the Supreme Court and its power. Perhaps also addressing some misunderstandings about the nature of the Supreme Court's power. There are some things that I think show up often in, say, high school civics textbooks that are simply false, and I'll try to point those out, even if though in practice they might point to something that's correct. And then at the end, I'm going to focus on one particular part of the Bill of Rights, the First Amendment, but also just freedom of speech in the First Amendment, because I think it's really crucial to drill down into one of our most fundamental rights and what the founders, the people who wrote the Bill of Rights, what we think they meant by freedom of speech, but then also how the Supreme Court has interpreted freedom of speech today, so that you're aware of it. And this is something I do think matters for citizens, particularly as you go and interact with local government. Some of what I'm going to talk about, I think some of you might actually confront in your interaction with local or state or even national government. All right, so I'm going to go ahead and share my screen, pull up my PowerPoint, and then we will get started. Let's see. It is not showing. Let's see. Oh, allow Zoom to share your screen. All right, it looks like I have to, my computer is now forcing me to update something. I apologize for this. This is unusual. It is not letting me share my screen here. Share. There we go. Hopefully this does the trick. All right, so there we go. Now it's working. All right. So the judicial branch and the Bill of Rights, judicial branch and the Bill of Rights. The first thing that I want to talk about is the judicial power itself. And this is something where there's, I think, a significant disconnect between what the Constitution actually says and what people think the Constitution says. So here I just have the first sentences, clauses from Section 1 and Section 2 of Article 3 of the Constitution. The judicial power of the United States shall be vested in one Supreme Court. And it goes on in such inferior courts. The part about the salary there is important because that protects judicial independence. You know, Congress can't lower the salary of judges as a way of trying to manipulate their behavior. But then you have the first clause there from Section 2 of Article 3. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and then it continues. I put this up there because many people, if you were to ask them, what does the Constitution, what power does the Constitution give to the Supreme Court? They would say judicial review. The power of judicial review. And the power of the judicial review is the power of the Supreme Court to strike down laws as unconstitutional. Now, you see these sentences here outlining the judicial power. Nowhere in them do you actually see this power of judicial review. It is possible for something like judicial review to be implied here, but it is not clearly stated. There's something else that is important, because when we think of judicial review, we also think of it as being the power of the Supreme Court to be the final interpreter of the Constitution. And that quite clearly is not here. However, today, again, if you were to ask people who's the ultimate or supreme interpreter of the Constitution, people would say, oh, it's the Supreme Court. Nowhere do they give the Supreme Court this power, though. Nowhere does the Constitution actually vest that kind of authority into a body of unelected life-tenured judges. So then you have to ask yourself, well, where does it actually come from? Where does it actually come from? Well, again, sometimes the answer is Marbury versus Madison. People will say Marbury versus Madison. And this is a major Supreme Court case from 1803. Although interestingly, at the time that it was decided, it was not considered a terribly significant Supreme Court decision. It was only over time, over many decades, that people came to see it as a significant Supreme Court decision. Well, the issue in Marbury versus Madison, the facts, well, are pretty interesting, but they're a little technical, so I'll try to be very brief. But basically, there was a guy, William Marbury, who had been given a magistrate position at the end of the Adams administration. His commission wasn't delivered at the end of the Adams administration. The Jefferson administration came in and wouldn't give it to him. And so he sued and went straight to the Supreme Court and said, hey, make them give me my commission. So there's this big controversy over that. But what ends up being most important about it is that for the first time, the Supreme Court actually exercised the power of judicial review to declare that a law or part of a law that had been passed by Congress unconstitutional. Now, some people, again, they read Marbury versus Madison, and they think that within Marbury versus Madison, there's actually a more aggressive claim than is actually there. They think that in Marbury versus Madison, the Supreme Court said that it was the final and ultimate interpreter of the Constitution. Nowhere does the Supreme Court actually say that. John Marshall, Chief Justice John Marshall, the most important Chief Justice in US history, he wrote the opinion. Nowhere does he actually claim that. In fact, the more you know about the Supreme Court during this period, you know that it would have been impossible. It had been politically suicidal for him to actually make that claim, because Congress really didn't like, Congress was controlled by a party that was opposed to the Supreme Court, or the justices of the Supreme Court, the Democratic Republicans, Jeffersonian Republicans. You also had a president who was opposed to it's largely known as the Federalists, who were on the Supreme Court. So that was Thomas Jefferson. If Marshall had actually come out and said, we're the supreme interpreter of the Constitution, Congress and the president would have really attacked the Supreme Court and would have been successful in doing so. In fact, for a couple of years, 1801 and 1802, the Congress didn't even appropriate funds for the Supreme Court to meet because they didn't like it. right? But Marbury versus Madison, you could say, planted the seed that would eventually grow into judicial review and then perhaps into judicial supremacy. I think the best way of explaining this power of judicial review is that it's simply something that developed over time, over many, many decades, and that eventually Americans just seem to accept the idea that the Supreme Court should be the final and ultimate interpreter of the Constitution. But nowhere again in the Constitution is that power actually given to the Supreme Court. Sometimes people hear that, and they think, well, what else would the Supreme Court do? Well, actually, lots of things. In fact, most cases that the Supreme Court hears have nothing to do with constitutional interpretation. The vast majority of cases. It's a very small number of cases where the Supreme Court is actually called upon to try and determine and apply the meaning of the Constitution. Most of them are, you would say, statutory cases. All right, so that might be a little bit confusing since I'm presenting some information that I think is often incorrectly presented in some of our civics classes. But I think it's actually important. It's important for American citizens to understand what the Constitution actually does say about the power of the Supreme Court and the judiciary. All right, so let's move on to the next topic, the application of the judicial power to a particularly important part of the Constitution, and that would be the Bill of Rights. The Bill of Rights. Again, this is something that's interesting because if you go and read the Bill of Rights, as it was initially written, it's pretty clear that the Bill of Rights only applied to Congress, that is, to the national government. The Bill of Rights only applied to the national government. But if you actually look at most controversies surrounding the Bill of Rights today, they are controversies that have arisen out of state and local law. So the very first word of the Bill of Rights is Congress. Congress shall make no law. Congress shall make no law respecting establishment of religion or prohibiting the free exercise thereof. And then goes on to talk about speech, press, assembly, and petition. We'll say more about those rights in just a second. But initially, it only applied to Congress. And there, in fact, were Supreme Court cases. A very important one called Barron versus Baltimore in the 1830s on whether or not the Bill of Rights applied to state government. And the Supreme Court said, no, it did not. The Bill of Rights did not apply to state government. So therefore, the protections of the Bill of Rights were only protections against the national government. So then you have to ask the question, well, how is it that most of the controversies surrounding the Bill of Rights, where the Supreme Court actually applies the Bill of Rights, involve state and local governments? The answer is down here, the doctrine of incorporation. The doctrine of incorporation. So what has happened is that the Supreme Court has incorporated most of the Bill of Rights, not all of it. There are sections of the Bill of Rights that still do not apply to the states, but most of the Bill of Rights has been incorporated to apply to the states through the Due Process Clause of the 14th Amendment. There are all sorts of technical issues that arise from that, whether or not that was the right clause, all sorts of other things that go along with it. But that's the short story. The Supreme Court has applied the Bill of Rights to the states through the Due Process Clause of the 14th Amendment. Officially, what we have is known as selective incorporation because, once again, not all of the Bill of Rights has been applied to the states. For instance, the Third Amendment has not been applied to the states. That's the no quartering of troops. There are actually some lower court decisions where they've incorporated it to apply to particular circuits, but it's not been applied by the Supreme Court. Also, the requirement that all civil cases involving more than $20 be jury trials has not been applied to the states. There's good reason for that. I don't think that clause will ever be applied to the states. If the Supreme Court actually did do that, it would bring state judicial systems to a grinding halt, because you think about all the cases that are resolved through small claims court. All of those then would have to be done by jury trial. or you think about all the cases on Judge Judy or some of those other judicial shows. Those are essentially real cases where they've gone and found small claims court cases and asked the participants if they would be willing to go on those shows. So all of those cases would then have to be jury trials. Jury trials are enormously expensive and time consuming. So you can't imagine the Supreme Court actually applying that part of the Bill of Rights to the states. All right, so that's the how the Bill of Rights came to apply to the states. Again, most of the controversy that we have today surrounding the meaning of the Bill of Rights really do come out of state and local government. So moving along, I do want to focus on one particular part of the Bill of Rights, the First Amendments. The First Amendments. We can, during a question and answer, I'm happy to answer questions about other parts of the Bill of Rights. We can talk about the Second Amendment. By the way, for a long time, that was the most significant part of the Bill of Rights that had not been incorporated. The Supreme Court did apply it to the states in a case called McDonald versus Chicago. Right? So there's some other issues that I'm happy to address during the Q&A. But the first thing that I want to talk about with the First Amendment is, and I'm not going to talk about the religion clauses, also happy to talk about those in Q&A, is that I think encoded within the First Amendment itself is the idea of self-government, and that the First Amendment points to self-government. So you see that there are 4 very important rights in the second half of the First Amendment: freedom of speech, press, assembly, and petition. Now, most people, once again, I think if they read the First Amendment, they think of those as being separate or discrete rights. That is, that they aren't necessarily connected. That there's a right to freedom of speech, it's its own thing. There's a right to freedom of the press, that's its own thing. Assembly, that's its own right. And then petition, that's its own right. But I think that's incorrect. I think that's incorrect, that there is, once again, this logic of self-government right there written into the second half of the First Amendment itself. So the first right that you see is freedom of speech. Freedom of speech. So you can think of it this way. Let's say that the government has done something that you think is inappropriate. You think it's wrong, and you think that it should be changed. Well, what are you going to want to do if you have sufficient courage? That is, right? You have to. That's one of the important thing about all of these rights here, is that you have to have the necessary courage to actually exercise them. But you're going to speak about it. You're going to want to speak about it. So that's the first thing. Government's done something inappropriate. You're going to speak out about it. Well, then what's the next thing that you're going to do? Well, it's not terribly effective to just go stand on the street corner and scream at people. All right. Maybe that makes some difference. You see people during campaign season, honk for my candidate, those kinds of things. I don't know. Maybe that changes some people's minds. But for the most part, that's not terribly ineffective because you aren't reaching very many people. So what are you going to want to do? You're going to want to use the press to try and reach a broader audience. So this is very important. Freedom of the press does not refer to the institutional press. This is also something I think is often misunderstood. Freedom of the press does not refer to the institutional press. And so what do I mean by that? It is not referring simply to people with press passes or press badges. So it's not referring to reporters from the Gazette or KRDO or CBS News or the New York Times or Washington Post. That is not what the press is referring to in the First Amendment. Instead, the press is referring to technology. The press means whatever technology is available for broadcasting your speech. The press is whatever technology is available for broadcasting your speech. So at the time, right, the press was the technology of the printing press. But of course, they well understood that there could be new developments, technological developments that would expand this. Right? So you have radio, and then television, and then the internet. Right? All of these things would would be included in the press. It's whatever technology is available for you to broadcast your message. So the institutional press does not have special rights that are not available to you and me. Instead, we all have freedom of the press. We all have freedom of the press. All right, so you're going to use the press to try and reach as many people as possible. So what are you going to do? You're going to use the press. You're going to say, hey, if you're concerned about what the government has done, why don't you get together with me and let's talk about it? So you're going to assemble together. You're going to assemble with your fellow citizens. So you're going to exercise your right to freedom of speech, then the press, then your right to assembly, and talk about what should be done. And then once you're done assembling with your fellow citizens, you're going to talk about what should be done and what you're going to request that the government do to correct what it has done. So then you will petition the government for a redress of grievances. So again, those rights all follow from each other, or you could say they build upon each other. Speech leads to press, leads to assembly, leads to petition, which reinforces the idea of self-government or citizen control of the government. All right, so let's now focus on one particular right, freedom of speech, freedom of speech. So the First Amendment does guarantee the right to freedom of speech. I want to say a little bit about what the original understanding of freedom of speech was. So I think that the best evidence, there is some controversy over this, but I think the best evidence indicates that freedom of speech meant no prior restraint and that it only applied to political speech. Again, there's some controversy over this, but I think this is what the best evidence points to. So first of all, what's the doctrine of no prior restraint? No prior restraint. What that means is that the governments cannot prevent you from saying something before you actually say it. Under the doctrine of no prior restraint, the government cannot prevent you from saying something before you actually say it. That is, it can't hear that you're going to say something in a newsletter and come seize your printing press before you print it up and distribute it. However, initially under the doctrine of no prior restraint, and this came out of England, English common law, you could still be punished after the fact. Part of the evidence for this is that shortly after the Bill of Rights was added to the Constitution, you had, so 1791 and 1798, you get the Alien and Sedition Acts. And in the Sedition Act, they actually made it a crime to speak ill of the governments. That was essentially what the Sedition Act said. And so they couldn't prevent you from saying bad things about the government before you actually said them, but they could punish you for it after the fact. And there were, in fact, people who were punished and thrown into prison. Benjamin Franklin's grandson was one of them for saying mean things about John Adams. The American people reacted negatively, though, to the Sedition Act. And so even though there was never any formal legal resolution to this, I think that there was a change in the public understanding that prior restraint was a necessary but not sufficient condition for the protection of freedom of speech. So the doctrine of prior restraint is still on the books. The Supreme Court will still apply it in some cases. They will say that, for instance, in the Pentagon Papers case, New York Times versus United States, that the government could not prevent the publication of the Pentagon Papers. There was a potential that the New York Times and other media outlets could be punished after the fact, but they couldn't prevent it. The second part of the original understanding was political speech. It's again, I think, fairly clear that they thought that political speech was the most important kind of speech, and that's what it was largely designed to protect. Of course, the difficulty comes in is how do you define what's just political speech? It turns out that this can be a pretty capacious category, pretty broad category, that all speech or much speech can have really important social and political effects and consequences and meaning. And so it's been as well broadened over time. All right, so I think that was the original understanding. But now I want to look at the contemporary interpretation of freedom of speech by the Supreme Court. And this, I think, I hope will be helpful for you, again, as you perhaps want to exercise your free speech rights, and sometimes those free speech rights might not be looked upon favorably by government officials. Right? So here are three basic doctrines. There are more doctrines, but I want to focus on these three doctrines that really undergird the Supreme Court's contemporary understanding and interpretation of freedom of speech in the First Amendment. The first is what's known as viewpoint neutrality. Viewpoint neutrality. And viewpoint neutrality means that the governments cannot censor or punish your speech based upon your motivating ideology. The government cannot censor or punish your speech based upon your motivating ideology. So that is, the government cannot say, we don't like the fact that you are a Catholic, or you are a Muslim, or you're an atheist, or you belong to the Flat Earth Society, and therefore we're not going to let you speak. That's your motivating. So I'm giving the motivating ideologies for the speech. It doesn't really address what you're going to say. It's just, we know that you're in one of these categories of people, right? You're Presbyterian, right? You're Mormon, whatever would happen to be your motivating ideology. The government cannot censor or punish speech based on that. I'm going to say more about content neutrality in a second, and there are exceptions to protection under what's known as content neutrality. I really only know of one, what's called an exception to protection under viewpoint neutrality, and that would be pro-drug speech in K through 12 education. There's a case called Morse versus Frederick. Some of you might have heard of it. It was somewhat infamously known as the Bong Hits for Jesus case. And the Supreme Court in its decision there said that pro-drug speech could be censored by school officials, public schools. Though, by the way, that's also something important as well. The First Amendment only applies to government. So it doesn't apply to private entities, except perhaps under some interesting circumstances, again, which we might want to cover in Q&A. Second basic doctrine, content neutrality. Content neutrality. In a second, I'll advance my slides and talk about exceptions to protection here. But content neutrality means that the government cannot censor or punish your speech based on the content of the speech. Cannot censor or punish speech based on the content of the speech, except for some exceptions to protection. And then there's what's known as public forum doctrine. And public forum doctrine applies to public spaces, publicly owned spaces, and then the rules that apply to government for speakers, private citizens using those public spaces for expressive activity. So I do want to say a little bit more about content neutrality, and then a little more on this public forum doctrine. So content neutrality. There are exceptions to protection. There are exceptions to protection under content neutrality. That is, that government can censor or punish speech in these categories of exceptions to protection. These are the exceptions. These are the official exceptions to protection. The first one, incitement. Incitement. Need to be precise here, though. This is incitement to imminent lawless action. Imminent lawless action. So that means it must be close, right? It must be close. It's not, incitement can't just be, well, I think that we ought to, maybe one day overthrow the government, right? That's not it. Incitement to imminent lawless action means that you're standing in front of a mob of people and you're telling them, go attack those people over there. And then they go do it, right? That's incitement to imminent lawless action. That comes out of what's known as Brandenburg versus Ohio. Second exception to protection, false statements of fact. False statements of fact, and in particular, libel and slander. Libel and slander. All right, so if someone is libeled or slandered, they can sue. And if someone did in fact libel or slander them, they can't say, "Oh, well, the First Amendment allows me to lie about people and slander them." You can't do that, right? You can't do that. People have a right to their reputation. Now, in the United States, it gets kind of tricky because we have different levels of proof that you have to meet to bring a libel and slander case. So for public figures, it's actually really difficult to win a libel or slander case. That's why celebrities always sue in Europe, right? Or England, where it's much easier to win a libel and slander case. But officially, false statements of facts, in particular libel and slander, are not protected. They are not protected. Next, obscenity. Obscenity. The Supreme Court has said that obscenity is utterly without redeeming social importance, and therefore it is an exception to protection. It's not protected. Now, again, this is a tricky one because you have to try and figure out what the court's definition of obscenity is. And the court moved in different directions over time, but now we actually have a fairly stable test that we use to define obscenity. And so, yeah, it turns out that states can actually punish a lot of obscene material, but often they just choose not to. They choose not to. Next exception to protection would be child pornography. And you might say, well, isn't that obviously included in obscenity? No, because there are certain kinds of pornography that are not actually considered obscene under the Supreme Court's definition. And so that if that pornography involves children, it also, you need this exception to protection in order for government to be able to punish it. Another exception to protection, maybe, is fighting words. Fighting words. This one, there's also some significant confusion about because it came out of a case called Chaplinsky versus New Hampshire from the 1940s. And the Supreme Court in other decisions has very clearly eroded the fighting words doctrine without officially overturning it. So there's disagreement about this. I happen to agree with the constitutional scholars, the First Amendment scholars, who think that really the fighting words doctrine doesn't exist anymore because other decisions have eroded it so much. So even though the court hasn't officially come out and said fighting words doctrine isn't there anymore, there's not much left of it, right? To the extent that you could say that the fighting words doctrine still exists, it's not just fighting words. Fighting words doesn't mean just speech that makes you angry. That's not it, or speech that you dislike, which sometimes people will say. Instead, I think the most you could say for it would be that fighting words are like a person-to-person invitation to brawl would count as fighting words, but not much, if anything, beyond that. Next exception to protection, true threats. True threats. All right. So if someone says, "I'm going to kill you," and they're sitting there holding a gun, right? That counts as a true threat. Counts as a true threat. You can see here, it kind of has the effect of an action. It's not just words, right? True threats in that circumstance has a very powerful effect on you, right? And then finally, speech that's owned by others. Speech that's owned by others is not protected. Hence, you can have copyright laws, right? You can't unlawfully copy a movie, broadcast it, and say that it's protected by the First Amendment. Now, there's one final category that's it's in a gray zone where it doesn't receive full protection, but it receives some protection, and that's advertising. So commercial speech, commercial advertising. But over the last 40 to 50 years, the Supreme Court has consistently increased protections for commercial advertising. Now, you might be looking at this list and saying, Professor Dunn has left an obvious exception to protection off the list. He doesn't know what he's talking about, because I've heard people talk about this on the news, and I've seen people say it on Twitter. All right. The category that people often think is an exception for protection, but it is not. It is not. It is fully constitutionally protected speech, is hate speech. Hate speech. The Supreme Court has made it abundantly clear for decades in unanimous and nearly unanimous opinions, we're talking 8-1 and 9-0, that the Constitution protects the speech that we hate. And therefore, hate speech is not an exception to protection. It is not an exception to protection. If you hear someone saying that hate speech isn't free speech under the Constitution, you can immediately assume they have no idea what they're talking about, because they don't. Now, maybe you could say that it should be an exception to protection, but it is not right now, and it's not close to being an exception to protection. It's not like there's a significant ideological divide on the Supreme Court over this. All right. Again, the liberal bloc and the conservative bloc all agree that hate speech is protected under the Constitution. And again, we can talk about the reasons for that in the Q&A, but I just don't see any circumstances, anytime within the next, easily within the next 15 to 20 years, that changes. You would just have to have enormous changes in the composition in the Supreme Court, as well as the potential candidates to be Supreme Court justices. So I don't see it changing. All right. Finally, I want to say a little bit about public forums, public fora, because this is something that citizens, I think, should be aware of. So there's what's known as the public forum doctrine. And so what's a public forum? It's public space that's open for expressive activity. There are what you call traditional public forums. Those are things like sidewalks, public parks. Now, the government can restrict expression in a traditional public forum, but they can impose legitimate or reasonable time, place, and manner restrictions. Time, place, and manner restrictions on expression in a traditional public forum. So that would be like, well, you can have a parade on a city street, but it can't be after 9 o'clock at night. It can't be in a residential neighborhood, and the speakers on the floats can't be louder than a certain decibel level, something like those. So that would be time, place, and manner restriction. However, if the government is going to restrict expression in a traditional public forum, it cannot violate, this is crucial, it cannot violate viewpoint neutrality and content neutrality. Can't violate viewpoint neutrality and content neutrality. In other words, it can't say, you know what, we're going to give this anti-Columbus Day group a permit to have a parade, but we aren't going to give a permit to the pro-Columbus Day group to have a parade. That would be discriminating both on viewpoint and content. Viewpoint and content. Then there's what's known as a limited public forum. Limited public forum. And a limited public forum is public property which is open to the public on a limited basis for expressive activity. Now, there's one primary kind of limited public forum in our system. There are more, but the most common one would be public schools. Public schools. For instance, the use of public school facilities for student clubs after school. And the same rules apply. Public schools don't actually have to allow students to use their facilities after school for any kind of expressive purposes. However, if they let one group do it, then they essentially have to let all of them do it. So you can't say, we're going to allow the chess club to meet, but not a Bible study. Right? Because you have now allowed the pro-chess viewpoint to have access, right, to this limited public forum. But you can't say you also can't say we're going to allow the Bible study to meet, but not say a gay-straight alliance to meet in the school. So again, the prohibition on viewpoint and content discrimination applies to a limited public forum as well. Then finally, you have what's called a non-public forum. Non-public forum, and that is public property that is not open for expressive activity. And there are two primary kinds of non-public forums that we have. One would be the polling booth. Now in Colorado, since we have mail-in voting, this isn't as big of an issue anymore. But it used to be, right, that if you went to vote, right, you went to your local precinct to vote, you couldn't engage in electioneering activity at the actual voting booth or at the facility where the voting was taking place, right? The other kind, we actually have several of them here in El Paso County, would be military installations. All right, so it's not going to do you any good, right, if you march up to the entrance to Fort Carson, holding signs, complaining about the U.S. military and saying, "Let me on the base because I want to complain about the military, and the First Amendment allows me to do so." It will not go well for you. This is a non-public forum that is not open for expressive activity. Now they might, of course, people are going to be able to say things on a military installation, but it is controlled by the military, and they have the authority to decide what can and cannot be presented in that space, by and large. All right, so I'm going to stop sharing my screen now, and then open it up for any questions that you might have. So, yeah, I could not see any hands raised while I was talking there, but any questions on the Supreme Court, the Bill of Rights, and then the First Amendment? Or was I just abundantly clear and you are all going home feeling completely enlightened by what I had to say? It's no controversy.
I'll take one for the team, Josh. I'll go ahead and ask a question.
Yeah.
We've been hearing a lot lately about big tech's role in freedom of speech and who should be allowed to say certain things and what might be not allowable. And do these companies have the ability to kick people they deem inappropriate off of these platforms? What's your take on that, and what can you anticipate that we might see in terms of judicial decisions on this issue in the near future?
Yeah, so in general, the principle is if it's owned by a private company, they can decide who gets to say what on their platform. That is, that Twitter doesn't have to create this platform and then just allow anyone onto it. It's their private space. And just because they invite lots of people on it doesn't mean that they can't kick you off, So that's the general rule, right? That is the general rule. There might be certain circumstances, though, where First Amendment principles could apply to private actors, potentially even to some of these social media companies. So sometimes if a private actor engages in activity at the behest of government, that essentially turns their behavior into government behavior. So what some people have argued with Twitter and Facebook and others is that they have started to kick off or censor certain speech on their platforms because of pressure from Congress. And if that's the case, if they actually have censored because of political pressure, then that does open them up potentially for litigation, claiming that they've essentially converted themselves into an arm of the government for those purposes. I don't know. I think we're going to see litigation like that. I think there's a broader question, though, which is about just an ethos or cultural support for freedom of speech outside of the First Amendment, right? And so I think that's actually where the more interesting conversations are happening on this. So you think about old public houses in New England in particular. Those were privately owned establishments, but they were called public houses because that's where everyone came to talk about stuff, right? All the issues that were affecting the local community. And so in some ways, these social media platforms have become the new public house. And it's really is an important question about what access to those should look like. There's debate about this Section 230 and those kinds of things. My guess, though, my guess is that the Supreme Court, unless there is very clear and convincing evidence that the social media platforms have censored individuals directly because of political pressure, that they're going to say they're private platforms and they can do what they want. That's my guess. That's my guess. I see some questions in the chat. First one, yes. So refer to someone when the hate speech is protected speech. Well, that's actually a really interesting case just from a few years ago called Mattal versus Tam that I would recommend that you read. It addresses this. Also, the Westboro Baptist case, citation is escaping me at the moment, but this was an important case reaffirming that hateful speech is protected. And then RAV versus St. Paul as well. This is a major hate speech case from early 1990s. And then you could go back even to Roth versus United States. This was an obscenity case. It's made quite clear. There's actually, the statement is there in that case that the First Amendment protects the speech that we hate. All right. So those are some of the cases that I would point to. Other questions. Again, a lot of interest in hate speech. I do not have a definition of hate speech. That's part of the problem, is that it's really difficult to actually define hate speech in a coherent way that doesn't just become inflationary. And I have actually in the past talked about what you could call hate speech inflation. I mean, there's obviously speech that we could all identify as hateful. People using racial epithets, those kinds of things. But it's, and I think this is part of the reason the Supreme Court is not interested in actually making hate speech an exception to protection, is that it's impossible to define it in a confined way, a clear way, where it just doesn't devolve into speech that I don't like. There's another issue, right? There's another issue, which is that it also then makes the exercise of someone else's individual right contingent on someone else's response to it. And that's not how rights work, right? If you have a right to something, you get to decide how, by and large, how you exercise. It's not contingent on the subjective reaction of someone else. And so some of it is driven by, well, one person might find the speech particularly offensive and hateful, but many others wouldn't, right? And so then this one person who does find it offensive or hateful then gets to control your individual right. So yeah, it's just difficult, again, to define in a way that is actually consistent, that could function as a clear legal rule. Question about when hate speech is predatory or threatening, is that still protected? No, true threats, right? So again, true threats are not protected. But it has to be a threat. It's not just that you don't like it, right? It would have to constitute an actual threat. All right. Again, suggest a book on the Constitution for study. Again, I have lots of recommendations on that. So, Shannon, we might want to send out another email, but I'll just go ahead and throw out a few off the top of my head. But William Rehnquist actually wrote a very good book just on the Supreme Court as an institution. So I'm looking at it right on my shelf right now. It's just called The Supreme Court. So former Chief Justice Rehnquist. That's a very good just introduction to the Supreme Court. Another book, it's actually right above Rehnquist's book, is called America's Constitution by Akhil Amar. And Akhil Amar is a law school professor, constitutional scholar at Yale. And so this book, America's Constitution, is quite good. He also has a very good book on the Bill of Rights, just called The Bill of Rights. So I would recommend that as well. Then there's another very fascinating book and called The Brethren. And it was written by Bob Woodward, and I can never remember his co-author, but it was Bob Woodward of Watergate fame. And it just looked at about 8 years of Supreme Court history from the late 60s through around 1976, 1977. And what's fascinating, it really does give you an insider's view of the Supreme Court, because what Woodward was able to do was convince at least a couple of justices to talk with him about the internal workings of the court. And the court is a very secretive institution. It doesn't like to disclose or divulge what happens inside of its marble walls. And Brennan got a couple of justices and several clerks to talk to him about it. And when the book came out, a lot of defenders of the Supreme Court criticized it as little more than just tabloid trash and gossip and speculation. But really only one thing has happened since the book has come out, is that as documents from that period of Supreme Court's history have been opened up, so as, for instance, Supreme Court justices have retired and put their made their archives available, typically after they die, what's happened is that the Brethren has been confirmed, right? It's just, most of it is accurate. So that's really interesting. There's another very good book called Supreme Conflict, written by Jan Greenberg. Her last name has changed though, I think. It covers Supreme Court history, late 80s through the early 2000s, if I recall. It's kind of like a nice companion to the Brethren, right? But also gives you some of the inside stories of what's going on the Supreme Court. So those are a few, but we'll send out an email with some of those. So I see a hand raised, Tony.
Trying to unmute, sorry. So you didn't go over, or I didn't hear you go over the 9th and 10th Amendments on the Bill of Rights. Yeah. And it seems as though Congress has been grabbing more and more and more power, especially through the 20th century, but even before that, 21st century, when it very specifically says in the Bill of Rights that they have limited powers, and they have to be they're the ones that are listed in the Constitution.
Right.
What do you see anything coming about where those amendments actually mean anything anymore?
Not really, because I don't know that they actually give you much constitutional substance. So, and let me explain why. So you think about the 10th Amendment, right? It says all powers, right, not given to the national government are reserved to the people and to the states, right? So the exercise I like to conduct with my students on this is to imagine that you were given the task of writing a program to interpret the Constitution. Right? Then to be able to decide whether or not a piece of legislation is constitutional or not. Right? So you would give instructions, commands to the program to do certain things. So you would say, read Article 1, or look at Article 1, right? And then you go through a bunch of sub commands, right? Look at the different sections of Article 1, right? And then you keep doing that. Once you get to the 10th Amendment, what would you tell the program to do? Essentially, the command that you would give to the program would be to repeat all the steps you've already just conducted. Right? So how would you know what actually is given to Congress, right? Well, you just got to go back and repeat all what powers are given to the government. You go back and so, in other words, it doesn't actually give you a whole lot, at least obviously, to hang your constitutional hat on. Now, it could be that there's a substantive component there. There are scholars that have worked on this to argue that there is something there. But for Supreme Court justices, Sandra Day O'Connor, for instance, was one who really tried to develop jurisprudence of the 10th Amendment and could never really quite work it out, right? So instead, I think that if you want to limit, say, Congress's power, your best bet is still just go back to Article 1 of the Constitution. Let's look at the Commerce Clause, right? How has the Supreme Court interpreted it? Well, it seems to have interpreted it in a way that gives Congress vast powers that resemble what's known as the police power. And the police power is the power of government, a general power of government to legislate to protect the health, welfare, safety, and morals of the people. This is very important. Congress does not have the police power. It does not have the police power. So if you interpret part of Article 1 to essentially give Congress something that looks like the police power, you know you've made a wrong turn. All right. And you can't just say, oh, well, the necessary and proper clause just lets them do whatever they want. No, they did not include a clause that they thought would just allow Congress to do whatever Congress thought it should do. So I think that's your best bet. And we have seen the Supreme Court move in that sort of direction. So yeah, good question. So let's see. Book on passing it. I'm going to hold off. Amanda, we can talk about that on Facebook. Maggie, do you see political correctness as a hindrance to free speech? Yes, I do actually. At least in some circumstances, it can be a hindrance to free speech. Where you often will see it as an actual free speech issue will be on public university campuses. Right? So private universities are not bound by the First Amendment. Right? They are not bound by the First Amendment. Public universities are bound by the First Amendment. So sometimes you will see public universities censor speakers because they find the speech offensive. Sometimes, well, we have actually seen many public universities establish speech codes that have basically said you can't say things that offend other people based on certain protected categories. Every public university speech code, and by the way, I think those speech codes have arisen out of this ethos of political correctness that can exist on some campuses. Every single speech code, public university speech code that has been challenged in court has been struck down as unconstitutional. Every single one. I don't think that you can actually write a constitutional speech code for a university. The only constitutional speech code that you could write for a university would be redundant. It would be, it would just list those exceptions to protection under content neutrality, right? That would be it. Right? We're allowed to prevent you from incitement to imminent lawless action, from libeling and slandering your peers, from issuing true threats against them, from displaying obscene material, right? Those things. But you don't need that because those things are already punishable basically under state law. Like I said, any constitutional speech code would largely be a redundant constitutional speech code. But there was a big effort for a lot of universities to impose these speech codes in the 1990s, early 2000s, but most universities got the memo. If you create one of these speech codes, someone's going to sue you and you're going to lose. Today, there's an organization called the Foundation for Individual Rights in Education that really solely exists to sue universities. And they win all the time, right? And now they don't have to actually go to court most of the time. They just send a letter to a university saying, hey, what you're doing violates the rights of these students, or it violates the rights of these professors. So knock it off, and the university will stop. Basically, it's a really bad day for you if you're a university administrator and you get a letter from the Foundation for Individual Rights in Education, right? So now for a while, they would tend to try to defend themselves in court. Most of the time, they know that if you're getting a letter from fire, you're going to lose. So, all right. Well, I think we're right at the end of our time. So if you have any additional questions, feel free to email me, and we'll of course send out some of these reading recommendations to you. But it's once again been a pleasure. Thank you for tuning in, and I will turn it back over to Shannon.
Yes, just to echo what Josh said, we really appreciate you spending an hour with us on Thursday nights. I hope you enjoyed the conversation as much as I did. Just a quick reminder that we are off next week. We're taking a little break on April 1st, and that's because Professor Dunn is actually going to be working with some secondary educators instead that day. But we will be back on April 8th at 5 p.m. And we will have a discussion on the history and evolution of political parties, which is going to be absolutely fascinating and fantastic. I'm so looking forward to it. It's going to be taught by Professor Verlin Lewis, who actually has just a recently released book on the subject, and it's been very well received, and I'm actually in the middle of it right now. So I'm looking forward to that. Thank you all again. We did have a recording of this session that I'll make available to all of our attendees. And I'll also send out an email with all of those book recommendations that Professor Dunn offered. So have a wonderful evening, everyone. And thank you so much for being with us. Bye-bye.